আমি করবো মামলা করা যাচ্ছে না। I'm for the petition. Oh. Presence of my lord, the respondent is required because to these applications, the matter has not come at our instance. In due course, it has appeared. For the first time, as hearing the matter is appearing, we have prepared our paper book.
Have you filed paper books?
No, paper book is here, my lord. Duto set আছে.
Respondent number, who is respondent number 1?
Union of India. Union of India. Yes, Mr. Probir Bhomik.
He's appearing.
Mr. Probir Bhomik. They're appearing for Union of India.
Along with Mr. Somrat Goswami is recorded in order number 31st of October 2025.
The paper book as filed on behalf of the petitioner.
My appeal, I was praying for not today only, if it could be taken up on Tuesday.
Monthly list. Yes.
Your Lordship, Tuesday.
Yes, next.
Monthly list, July monthly list.
Much of.
Well, I am appearing for the respondents.
I could not serve reply, my lord, the copy just now, my lord. Next day.
Monthly list July, in the meantime, you exchange your affidavits.
Just now, my lord,
it has been
just now,
received.
my lord.
Today I have received the reply.
Just now, my lord, I have given.
Yes.
So monthly
May I
list
be-
of
My lord, may it retain its position.
এই বলে দাও না।
But may I be permitted to file affidavit in opposition, my lord?
May I file reply?
affidavits as filed by the police are taken on record. At the learned advocate appealing for the respective party is the
my lord, I am for the petitioner, my lord.
Who is opposing him?
My lord, the dispute in between the, my lord, the two,
Who is opposing him?
my lord, the,
Against the state or private individual?
my lord, I am for the BSNL. And my lord, the two private respondents are also there, my lord. And my lord, kindly see the last order, my lord.
Who is the petitioner? Read petitioner?
I am for the petitioner.
Original applicant?
who is for the
Applicant is
respondent?
one of the wife. One of the wife, my lord, was the applicant. My lord, it is
Any
that,
advocate represented?
yes.
Who is that?
My lord, before this honorable court also, last 3-4 days matter was heard.
Who is
Lanet-
the advocate? Next Thursday, yes. Intimate to him next Thursday, yes. 31,
My lord, one Subhajyoti Ghosh, my lord.
he sent him a notice.
And my lord, what I am praying, my lord, there was the proceeding was initiated before the tribunal. And the last occasion, this honorable division bench was pleased to direct to stay all further proceedings of the tribunal. And my lord, there was also direction if the learned advocate of the petitioner will not contest the matter, in that case, my lord, matter will hurt. So, my lord, that interim order may be extended. Kindly see the last order, my lord.
The file to the. It is expiring when? It is expiring.
Yes, my lord, because my lord, if
কথা শুনে মনে হচ্ছে না কি expire করা।
It has already expired.
Interim orderটা কি আছে? What is the interim order? On last occasion, direction was given upon the tribunal not to take any coercive steps
yes, ma'am.
against the department. Then it is recorded that the interim order will not continue. Oh, this interim order is the department. আচ্ছা আর মিস্টার ঘোষ লার্নেট অ্যাডভোকেট অ্যাপিলিং ফর দ্য
My lord, I am for the, my lord, respondent, my lord. My lord, this matter was taken up, my lord, several occasions, my lord. But my lord, they are avoiding, my lord, they are appearing, my lord.
No, they were not avoiding. They were here yesterday when you were not there.
But I was here, my lord.
You were not there.
Your lordship, can you see?
Yesterday when it was called on, you came
No,
later, no?
That is another matter, my lord. This is, my lord.
Not this matter.
No, this matter. That matter has been fixed, my lord, on Thursday, that matter.
When did we fix it?
My lord, I am for the petitioner led by Mr. Othurup Banerjee, my lord. My lord, he has not come to the court, my lord. I pray for time in these two matters, 31 and 32. I am led by him, my lord.
Next Thursday.
Next Thursday, my lord, because there are similar matter, my lord, will
Let
appear.
it appear next Thursday?
Next Thursday, on Thursday, my lord.
Yes, call the.
Great.
Millard, this is Millard. Kindly recall, Millard.
Yes, give us the papers.
Yes, Millard. We are seeking the benefit of the order, Millard, passed by the Honorable Supreme Court with regard to Millard. Kindly read.
Mr. Das,
Millard, my junior informed him yesterday also.
This is the problem, na. Yesterday we saw him waiting. Today again he is not. You are there, na? Dekhi, tao, file the doc, file the doc. Yes, tell us what is the matter.
No. He is not there.
Then we are releasing the Pathad.
No, Millard. Millard, kindly, Millard.
It is
Millard, this is
becoming-
tribunal application.
Yes, you place your case.
Your lordship has the determination. Your lordships have the.
Paper book, paper not there.
No.
Paper book not
No,
there.
no.
Then you will be arguing from which paper?
No, this is the writ petition, only opposition reply.
You are ready?
Yes, Millard. I will do this. Millard. Yes.
Gives unnecessary Pathad.
Yes. Millard.
You are appearing in which matter, Mr. Nodi?
I'm 35 million only. I'm not answering as respondent number, Union of India only. 35.
35 we have not called.
না একসঙ্গে ওই 35 you are for Union of India.
Then who is the advocate who is the advocate representing those applicants?
Original application.
Mr. Himanshu Datta. 3435, Mr. Himanshu Datta for the applicant. And Mr.
Not Das.
Dash.
Mr. B.R. Das is 30.
B.R. Dash, Mr. B.R. Dash.
33.
Yes, has he come?
First
But he-
matter Maniklal court.
I have not seen him, Millard. Yesterday, Millard.
Let us understand, yes, what
Millard,
is the
here, Millard, whether a particular disciplinary proceeding against an employee, Millard, whether it should be guided by 2006 rule or before that, Millard, if the offense committed, Millard, prior to that in proportion of the rule. Here, Millard, the case is, Millard, your lordship is considering, Millard,
that Supreme Court decided the issue. You
decided the issue, they ordered to, আগের দিন জজকে দেওয়া আছে, একটু বার করে দিন না।
said-
ওইটা দিয়ে হবে, ওইটা বার করো।
Date of the Supreme
Supreme Court order, Millard, that is, Millard, date 26 September 2025. My lord, got it? My lords, এই জজ সাহেবকে দিন না, লুজ কাগজ ছিল, লুজ কাগজ।
Calcutta.
26/9/2025 অর্ডারটা দেখুন।
এই সুপ্রিম কোর্টের অর্ডারটা চাইছি।
26/9/2025 আগের দিন দিয়েছি।
হ্যাঁ 26 নয়, এটা একটা কপি আমি দেখি।
এইটা এই দুটো, এইটা এইটা কি
না না এটা
না এটা 6
Yes, the order of the Honorable Supreme Court dated 26.
ইয়েস
September.
এই দুটো দেখুন তো, এই দুটো কিনা না, এই দুটোই 6 আর
We have a copy here.
ইয়েস আচ্ছা, মিলাড মে আই রিড?
No, let us go.
আচ্ছা good. এটা applicable নয়। Applicable for the above mentioned. And then we find something there. Of course, কোটাই বলছি।
You have only one copy?
Which one, Millard? No, I have given 2 copies, Millard, on the last day.
Two copy. Your junior took back.
Took back?
No, you keep it.
No, Millard, kindly. No, Millard. It doesn't look nice, Millard. Kindly.
No, you keep.
No, Millard,
You
kindly.
place it. You keep. আমরা এটা কি-
No.
না, নিন না। আরে নিতে কি অসুবিধা আছে? বার করে দিতে।
ওদের
দেখো এখানে
সমান দেখি দেখ ক্যাটাগরিটা বার করো এটা ডেটটা কবে মানে CCS rules should have 37 and 65. CCS rules should
Yes, Mr. Vasu.
Yes. So Miller, this short point, Miller, that has fallen.
The court has decided that.
The court has decided there are two parts, Millard. In respect of this gentleman, Millard, the court has directed to condone, Millard, the amount, Millard, which stands to the tune of rupees 1 lakh or like that, the meager amount, the court says condone it. But the moot question, Millard, that falls for consideration before the Supreme Court and as well as your lordships, Millard.
So what happened to the charge sheet then? It was quashed.
The court 142 exercise and quash, because here, Millard, in this.
No.
But in this, no.
As regards application is not 142. That is 141.
Well, that is 141 with regard to 2006 applicability.
So the charge sheet issued under the new rules were set aside, saying that the 1968 rules will be applicable.
Right. No,
High Court
2006 rule will be applicable because 58 says
charge sheet was issued under the 1968 rules or 2006 rules.
2006 rules, Millard, charge sheet was issued.
Very good. Now the Supreme Court says. Now what did the High Court say?
Millard, the High Court said, Millard, before the Honorable Tribunal, this is Millard, WPC 38 of 2028-2.
Judgment dated February.
The judgment dated, Millard.
High Court said 65 rules will be applicable.
CCS rules applicable.
65 rules.
Yes.
So that has now been turned around by the Supreme Court saying that no, it will be 2006.
So yes, the point is no more recent Millard.
So then what happens to the charge sheet in respect of that person?
That gentleman, Millard, it says, Millard, was under the consumption.
No, there is no mention.
No mention.
What will happen to the charge sheet and the discipline? So it has abandoned because the
abundant because Millard, the Supreme Court had said, Millard, that we have been informed that respondent number 1 has superannuated, and the allegation against him was that some bills were passed which were not genuine for an amount. Supreme Court last sentence, Millard, thus as far as respondent equitus shall be given to the entire controversy.
So
that means nothing to be done.
In respect of the original applicants in these three matters.
In these three matters, Millard, your lordships were kind enough.
Manik Lal Kaur. One is Manik Lal Kaur.
And Ratan Krishna Pal. Ratan Krishna Pal and Manik Lal.
Another is Ratan Krishna Pal and another is Subrata Gangopadhyay.
Manik.
These are the persons.
Manik, Millard, Manik, Ratan Krishna Tapan
Mr.
Subroto.
Banerjee, please take your seat. Let him argue. Yes.
My lord, kindly seize the chart. Your lordships directed that I have to take instruction as to why, my lord, the same benefit with regard to the last portion of
We are
your.
coming to that. As
Yes.
we understood your point, we are wanting to know that in respect of these persons here, they have also superannuated.
Yes, my lord, that is my instruction. Yes.
So they have now they have you have not disbursed them the pensionary benefit.
Because, my lord, the CBI has framed them, my lord, trial is on, my lord. The trial before and CCS rule, my lord, also creates a bar.
No, let us first understand that they are in respect of them also the charges does not survive.
Because, no, my lord, in
view of this order.
In view of this order, my lord, in that case.
Was it a single separate disciplinary proceedings?
Absolutely.
The charge sheet was same date.
No, different date, 2007 is the date of commencement of this
But
developmental
then let
proceeding.
us understand. Then the proceeding against them does
Yes.
not is no longer survive in view of this order.
In respect of this gentleman, my lord, this gentleman.
In respect of this gentleman, you are saying that 142 was exercised as regards the arrears and the disputed amount.
Right.
Court said that in these peculiar facts, whatever you have given to the respondent number 1, you
Right.
will not take it back.
Right.
This is
Now, my lord,
the facts of this case.
this is fact of the case.
But the main issue as regards survival of the disciplinary proceedings, that issue is no longer there. That
My lord, by reason of the division bench order, my lord, the order under appeal before your lordship, my lord, it categorically says that invocation of Rule 2006 is absolutely, my lord, without jurisdiction, and that is why court interfered. Let us place the order, my lord. The order that was.
Please, Mr. Vasu, our queries are there. Please answer our.
Lord, your lordship says that the departmental proceeding. What is the fate of that?
What has been the fate? What has been the fate after this judgment? Whether you can re-argue that those proceedings should.
Yes, I can re-argue because I have said, Miller, this chart indicates, Miller, the chart I have just handed over, that what are the fundamental difference between the gentleman, Miller, who went to the Supreme Court and the petitioners.
We are saying all the gentlemen were issued charge sheet.
Right.
Applying the provisions of this.
2006.
2006.
Correct.
High Court said, all right, right decision, 2006. Supreme Court said that it will be 60 High Courts, right?
No. High Court said that you cannot invoke 2006.
High Court said 65. Supreme Court has clarified saying it should be 2000.
Correct.
So the charges do not survive. Proceeding goes. Now you argue on this point. You tell us whether if those persons have been superannuated, how much money has been given to them in respect of those persons. And then you argue that don't direct us to give back that, not to take back that money from them.
No, first of all, yes, Miller.
No, am I clear?
No, Miller, yes, Miller. But the answer is, Miller, subject to correction, Miller, that if your lordship, Miller, take your lordship feel, Miller, that our case, there are fundamental difference between the two factual metrics of these two cases.
Then you will be at liberty to take back the money which you have already paid.
Yes, not only that, no, because I did not release, Miller, the full pensionary benefit because of this case, Miller, the pendency of the criminal case. Mr. Dash had argued that withholding of their retirement benefits on account of the pendency of the criminal case, Miller, is contrary to law. In this case, Miller, which is your lordship's and Supreme Court's order, in that case, Miller, there was no criminal proceeding, Miller, filed by the CBI. He was not entangled with the criminal charges. In these cases, Miller, the severe criminal charges are there. And Miller, the departmental proceedings are
of others,
I said, my lord, the first departmental proceeding, your lordship's query was exonerated. Second departmental proceeding was not completed. Honorable Cat quashed the charge sheet.
not so far. Ratan Krishna Pal.
Ratan-
Disciplinary proceedings.
Ratan, yes, yes,
You take that tabular form given to us.
yes.
Ratan Krishna Pal.
Departmental proceeding was completed before retirement, but CBI case is still pending. Ratan,
TP completed before
yes,
retirement.
yes.
But
Second,
you have not paid any.
yes,
You have not paid any retirement benefit. What was the punishment?
provident fund and provisional pension.
You have withheld.
No, paid.
Paid.
Where do we find that? In your chart?
No, in my chart, my lord, I was only demonstrating, my lord, the fundamental.
Federal benefits, pension, provisional pension, আর gratuity টা withhold করে রেখে।
এই কথায় আরো আছে। আচ্ছা, পেনশন প্রভিশনের গ্র্যাচুইটি উইথেল। পেনশন প্রভিশনের গ্র্যাচুইটি উইথেল। তপন দাসের সব পেড করে দিয়েছে। আর ইন রেসপেক্ট অফ আদার পেনশন এত। আচ্ছা, সো DP completed, retired, DP completed.
In respect of every person, DP has been completed.
My lord, I will come one after another, my lord. So far as Maniklal Kaur, charge sheet issued, charge sheet quashed.
Charge sheet quashed by whom? By High Court.
By tribunal. Honorable High Court, Honorable Cat quashed the charge sheet.
Where are you reading?
The last page, my lord, or the chart I have handed over. The second column, first page, my lord, it starts from Director HR BSNL versus Maniklal Kaur. CBI case
In
pending.
respect of Ratan Krishna Pal, you have completed the DP.
Right.
And punishment order imposed. What was the punishment?
What was the punishment?
Taking into the account of the page 78 of the writ petition, entire records of the case and on objective assessment of the facts and circumstances, on obtaining the necessary approval, Authority ICC KK Sapra, Chief General Manager, Calcutta Telephone Disciplinary Authority in exercise of powers conferred upon me by BSNL, CDA rules hereby order that the pay of Ratan Krishna Pal be reduced by one stage in the time scale of pay 20,600 to 40 such for 1 year with immediate effect. It is further ordered Ratan Krishna Pal will not earn increment of pay during period of such reduction, and on expiry of the period, the reduction will have the effect of postponing the future increments of his pay.
Right. So against this tribunal order, High Court, they went to High Court. High Court said that you have proceeded under wrong rules. It should be under 6 years. Supreme Court says that no, proceeding done by BSNL is right because that has been done under 2006 and 2000 is applicable. This is the chapter. So please tell us, Mr. Basu, in respect of Ratan Krishna, Maniklal, Topon Das and Subroto Gangopadhyay, what had been the punishments imposed about? Then the punishments becomes workable due to this order. The manner in which you conducted the proceeding, charges were established, you imposed a punishment. Supreme Court has upheld that.
Yes.
We
Yes.
will hear him that what order. Now, what further grievance you have now?
No, will it
If the
because
disciplinary punishment order survives after the Supreme Court order, now what can be the further? You will deduct the punishment and hand over the remaining. This is the only thing.
yes,
Here
Millard, first of
you
all,
are bringing an issue that there is a CBI case pending for
right.
which we only to cut short the litigation. We want to know from you. Suppose in respect of Ratanlal, there was 3 increments were stopped. Maybe now
Right.
nobody were dismissed. Anybody was
Millard,
dismissed?
no.
So it is a quantum of punishment which you have imposed.
Yes. Now, my lord, your lordship's query, my lord, if I am to answer, the first of all, my lord,
No, then what we are wanting is, Mr. Basu, today you please take instruction and tell us, are you prepared to pay them the benefits after deducting the punishment which has been issued? Suppose punishment there are the 3 increments cumulative effect maybe, it's like that. So,
so what
department-
remains further?
Uh-huh.
What remains further after the conclusion of the disciplinary proceedings? If I have resorted to 2006 rule,
Right.
if the courts do not disturb the findings as per
Right.
the Supreme
So
Court,
the
then
punishment
the
is
matter ends.
final.
Yes, it comes to a logical end. That you allow him to retire. Now you pay the remaining amount. Now what is the bar?
What is the
The
revenge?
bar is, my lord, I argued, my lord, that CCS Pension Rule 1972, my lord, in this type of circumstances, which is not in your lordship's hand,
Please
my
give
lord,
us
what
the
does the
rules.
law say?
Please give us the rules.
Xerox nahi?
No, Mr. Das, what had been the punishment imposed
My
upon
lord,
him?
my case is now very simple, my lord, as far as Maniklal Kaur is concerned.
You are appearing for Maniklal only.
I am only
Oh,
Maniklal.
if Maniklal is there, my
Actually-
lord, I was addressing on Ratan Krishna.
No,
Maniklal, my lord, the proceedings should squash, start sheet.
No.
So I have to start.
no,
Oh,
yes.
in this, the
Mane
proceeding-
all,
He is Maniklal.
Charge sheet
my lord,
was,
all the
Although
case-
he said initially that he represented both.
এই যে cat was.
No.
বলেছিলেন।
সেটা তো
বলেছিলেন।
হয়ে গেল, ওটাই তো
আমি সব
সমস্যা
শুনেছি।
হচ্ছে। ক্যাট কস করলো, হাইকোর্ট বললো যে না এটাতে 2006 রুলস অ্যাপ্লাই হবে, সেই জন্য কোয়াশিং সেই জন্য ট্রাইব্যুনালের অর্ডারটা তাহলে প্রসিডিংস
সেটাই তো বলছি, হ্যাঁ ওটা দে।
এবার হাইকোর্ট বললো না, হাইকোর্ট
ওটা কি
বললো
বলছে তো?
1965 এ করবে, এবার সুপ্রিম কোর্ট বলে দিল 2006 এ করবে, তাহলে 2006 এ করে থাকলে পানিশমেন্টটা ইজ ভ্যালিড হয়ে গেল।
ওদের অরিজিনাল
Valid হয়ে গেল। What is the punishment given in that case?
সেটা আমরা পারবো আপনাকে।
আমাদের তো আগে এটা করে তারপর ওর এই আর্গুমেন্টের
ওদের বলবো
আসলে ওইটা ফাইল করেছিল কবে?
উপর পাঠাচ্ছি।
তাই ঝট করে নিয়েছিল আসলে সামনে খাতায় ওই ইয়েটা।
Mr. Basu, for our convenience, we are wanting Ratan Krishna Pal, you said that the DP has been completed.
Punishment
It has
imposed,
been imposed.
imposed.
So in this Ratan Krishna, I want from you, we want this instruction that what will be the fate of Ratan Krishna or not? Whether you will release the benefits
Yes,
after deducting the, if that is so.
that has been done. We complied with everything.
Oh, that has been done.
Done. Now, Millard, the order has been, Millard, that the order, punishment order, Millard, that has been done. Now, Millard, today, your lordship's query, what remains then? Now, my answer would be that since Ratan Lal has been implicated in a CBI case, whether the law creates any impediment in releasing, Millard, the benefits, other benefits attached to his service.
Gratuity
That is what I argued, Millard, before when your lordships used to sit, Millard.
Now, who is for Maniklal? Maniklal is not.
Who is Maniklal?
my lord,
You are Maniklal.
in the change context, Maniklal becomes separate, my lord, now.
No.
Because in Maniklal's case, only the gratuity is withheld. And gratuity is withheld under Rule 69 1C of the CCS Pension Rule 1972. The Honorable Supreme Court, while giving a quietus to the controversy, because the controversy is dating back to years, even decades. So they gave a quietus to the
No, Mr.
controversy.
Mr. Das, that observation of giving quietus shows that in the facts of the case, Supreme Court exercised 142. At the ends of justice.
My
Basu says that this analogy will not apply in respect of Maniklal because we have withheld his gratuity since he is involved in a CBI proceeding.
my lord.
And now he wants to argue that let the court decide that whether it becomes a new cause of action. Your proceeding has attained finality. Punishment imposed. You suffered the punishment.
Millard, sorry,
No.
I'm sorry for the
No,
interruption.
he is not
No,
right.
no,
He is not right.
no. Millard, he is consciously making the submission. I said, Millard, I was confined to the submission and the court's query with regard to Ratan Lal. I was addressing my lordship on Ratan
That is
Lal.
the thing. That
Now,
is the thing.
Maniklal,
Maniklal,
sir.
what has happened?
Maniklal, what happened? এই চারটা দেখুন। চারটে একটু just
My lord, Maniklal, I am saying.
no, I am saying,
Yeah, Mr.
first departmental proceeding was exonerated, second departmental proceeding
Ah,
was not completed.
That is the main thing.
Go a bit slow, we are.
Sorry, my lord.
Exonerated,
becoming
that is the
old,
main
Mr.
thing.
Basu. We are not
Sorry, no,
young as required.
no,
We are
Milord.
becoming-
Sorry, my lord, I apologize. First departmental proceeding was exonerated. Second departmental proceeding was not completed, but the Honorable CAT Tribunal quashed the charge sheet. A CBI case is still pending.
Not started in,
So I want to start.
not started in.
Yeah, how could I? I challenge this order before I challenge this order before the High Court.
You want to reopen the issue?
Yes. If the, because, yes,
Yes, পড়া শুরু করো।
no, because we
And
trial is going on.
quash the charge sheet, you issued. ওইটা পেন্ডিং আছে।
Has filed for this court case inquiry held up. Now, Mr. Basu, what is this CBI charge sheet issue? CBI has issued charge sheet.
Trial is going on
Who is
against him.
in the criminal case?
Yes. And our charge sheet departmental proceedings stood
That is
quashed, gone. And High Court said, my lord, that
So
the
you are now taking the ground that since that CBI proceeding is pending, I will not disburse the benefits to.
I have two folds prayer that by reason of the High Court's order affirming the Honorable Tribunal's view with regard to the applicability of 2006 rules,
High Court, Supreme Court. said.
High Court also said, my lord, I am before your lordship challenging, my lord, Honorable Tribunal in Maniklal's case relied on, my lord, division bench judgment presided over by Justice Tandon. Now, the benefit was given to them, my lord, that yes, to invocation of Rule 2006 with regard to a misconduct alleged to have occurred, my lord, prior to the pronouncement of this rule. Now, my lord, we lost on that score. And accordingly, my lord, as a sequel thereto, my lord, the Honorable Tribunal was pleased to set aside the charge sheet. I came before your lordships, which is before your lordships, Justice.
Your charge sheet or CBI charge? sheet?
My charge sheet, departmental charge sheet. CBI charge sheet has not been questioned or possibly. Departmental proceeding charge sheet. CBI proceeding is continuing. The same was initiated before his retirement. That is the law. Disciplinary proceeding is instituted while the employee was in service, whether before his retirement or during re-employment, shall after the retirement of the employee be deemed to be a proceeding under these rules and shall be continued and concluded by the authority by
That
which.
is regarding continuation of the proceedings, whether you have the power to continue the proceedings even after retirement.
Yes, the answer
But
is that
regarding payment,
Mr.
Regard-
Basu, your proceeding is no longer there. If we have understood your argument,
yes.
that now today we cannot, though this has been the development, High Court order has been set aside, Supreme Court has said this. Question of revival of your proceeding will not arise. That is stopped, closed chapter.
No.
Now, you
No,
have to
Millard,
show us.
no, Millard, kindly, give me 2 minutes. Millard, in so far as Ratan Lal, I come one after another. Ratan Lal charge sheeted, disciplinary proceeding concluded. Up to that clear? Punishment was imposed.
What was the punishment?
The punishment I read, Millard, that
3 increments.
increments, that was complied. Now, Millard, during the subsistence of the departmental proceedings, CBI, Millard, lodged FIR, charge sheeted, criminal proceeding
In
continued.
respect of Ratan?
Ratan. Now, Ratan issue. Class Millard, kindly first take Ratan's.
Ratan does not say that.
Huh?
In your Ratan, CBI inquiry we do not find.
CBI?
The note which you have said, while posted as a
Departmental proceeding was completed before, but CBI case is still pending in Ratan, I've said.
separate things. One is the disciplinary proceeding, another is a
Yes.
criminal CBI.
Right, I am talking about both. This departmental proceeding was concluded, punishment imposed. During the subsistence of the CBI departmental proceeding, CBI had also filed a charge sheet, trial is going on, yet to be concluded. Departmental proceeding concluded with imposition of certain withholding of increment that your lordship has seen.
That has now attained finally.
Attain finality. Now the question is, so far as Ratanlal is concerned, that why I can't release the other benefits attached to his post. Ratanlal.
Yes.
My answer is, Milord, that CCS rules 1972, Milord, it says, it speaks about the consequence.
Let us take her one by one.
Yes.
Yes.
এই বইটা পাওয়া যায়।
Under what provision?
Milord, I am stopping, Milord, Central Civil Service Rules, Milord, Pension Rules 1968. এটা বই হবে?
1972.
1972.
72
Rule 68, sub rule 2, 69. Provisional pension. এটা জজ সাহেবকে দিন না, ততক্ষণ দিন।
Rule? No, then you will not be able to place.
Milord, Rule 69, provisional, may I read, Milord?
Okay. We have also.
It's 747.
69.
Rule page 747, 747. এই বইটা দিন না। জুডিশিয়াল প্রসিডিং কোথায় গেল রে?
It clarified way. It will get. Oh. Modest.
ক্রিমিনাল প্রসিডিং। Milord, provisional pension where departmental or judicial proceeding may be pending. No gratuity shall be paid to the government servant until the conclusion of departmental or judicial proceeding and issue of final order thereon.
Very good.
So I cannot give. Why it is?
Is also, I think, decided because
No, provisional
Supreme
pension.
Court has said that the Gratuity Act will override all provisions.
Milord, section.
We may
Yes.
be wrong.
No, I am not, Milord. I cannot say like this, Milord. But my understanding, subject to what my lords will say, Milord, this rule, whether was considered by the Honorable Supreme Court, this particular rule in the present facts and circumstances, why, Milord, the gratuity can be only withheld, Milord, under the Payment of Gratuity Act, Section 4, subsection 6 of the Payment of Gratuity Act. But here, Milord, it says whatever may be the consequence, if it's a judicial proceeding. Milord, if your lordship, my lord Justice Chatterjee, Milord, criminal procedure code পুরনোটা আছে? পুরনো criminal procedure codeটা আছে?
Milord, no, CBI proceedings is judicial proceeding.
Yes.
Okay.
So, Milord, today, no gratuity means it's a mandatory. The rule, Milord, is still in vogue.
But we have a question that whether Gratuity Act will overrule this rule or not.
Milord, Central Civil Service Rules, Pension Rules, Milord, 1972.
Gratuity Act.
Milord, kindly cease. Milord,
Where is your punishment order in respect of Ratanlal was stoppage of increments. Now thereafter this proceeding has attained finality.
Yes.
Now you are saying that no, I will
No,
not. You are saying now that
Yes.
in view of 69C,
Yes.
I will not disburse gratuity to you. Why? Because of criminal proceedings.
No, because, Milord, I cannot, Milord, I have not, I have, my action is not painted with any malice or imagination. I derive strength from 69C. It clearly says, Milord, that
So
no.
Your argument is we will not pay a single thing because
Milord.
judicial proceeding is pending. This is
As
your
far I say, because had it been a case like
Very
Milord,
good. Now we have heard you. We will ask for his answer.
No,
Then you will argue as regards.
he is not representing Ratanlal. His case is different. He wants it to take it in a separate.
No, at one stage we are saying, my lord, after this,
I am giving a provisional pension. We have been discharging with releasing provisional pension. He is getting that Ratan Lal. My senior friend is not, my lord, representing Ratan Lal. All along he has been saying. That is why he said Maniklal should be treated in a different compartment.
all the cases originated
I
from
will deal with
Maniklal,
this submission also.
and I was the author of Maniklal Court. That is why I
Then what is
intervened sometimes.
what is your answer to this argument of Mr. Basu?
My lord, actually,
The answer is
my lord,
proceeding, you have retired, you have been imposed the punishment. Then when you have retired, what is the rule? That whatever is the punishment that has to be deducted and remaining payment will be made. It attains finality. His argument is no. Even if that has gone, it has gone. Now I will not pay to you since you are involved in another proceeding. Why? Because 69C gives me that authority.
that
What
is
is your argument on that point?
my argument was there, my lord, lordship remembers. I was on the.
No, I don't remember.
And
Please,
no,
please
no,
tell us why
the-
this analogy
no,
will not be accepted.
after this judgment, of course, I have to be very cautious. After this Ratanlal judgment, I did not depend on it. Tapan Das. I did not depend on it, but I relied on it. And that was my, of course, difficulty because they immediately went to Supreme Court. And I drafted the affidavit in opposition there. Yeah. Actually, my submission before your lordship was that day. That till such time, I relied on documents. Still, I can rely on all the documents.
You answered on the proposition of law. You tell us.
Yes, my lord. Now, after this, I say Rule 58. He has also clearly said Rule 58 does away with all the hitherto applicable government rules upon a upon a government servant.
Rule 58.
Rule 58 of BSNL CDA rules.
Yes.
And of course, Supreme Court also agrees on that, says on that. Rule 58 is
296, page 296.
296, my lord.
Rule 58.
296.
Court-
Ah.
আপনাকে হারিয়ে দিয়েছি।
Any rules corresponding to this rule in force,
Which rule you are saying?
ওই ইয়ে,
Rule 58 of BSNL CDA rules.
BSNL rules.
BSNL CDA rules, my lord, that is at page
2006 rules. 2006 rules.
2006 rules. That was
We have not been given that rules.
actually in my brief, it is there.
Huh?
Tell us what is there in the rules?
No,
58.
the Supreme
Okay,
Court.
read.
58, tell us.
So BSNL CDA rule says, my lord, that was effective from 10/10/2006. I argued before your lordship that Rule 30, as per setting up order that was published on 1/10/2006, BSNL was formed. Only one day prior to that, that was formed. And they say clear stipulation was there. Clear stipulation 460. Clear stipulation was there.
Don't reopen the issue. It has been decided by the Supreme Court.
That was decided by the Supreme
Set a
Court.
race.
Now,
You give the answer that the authority is denying payment of the gratuity and the rest part
that's
of
what.
the
Yes, ma'am.
pension
Ah.
on the plea that a CBI case, a judicial proceedings is pending against you.
No.
Now, what is the answer?
Acha. In my case, my lord, in my case, I was telling your lordship that that the charge sheet was.
Ratan Lal, we are on Ratan.
I am on Manikkot, my lord. Manikkot, lordship for the time being opens the word Manikkot.
Mr. Basu,
Again, another-
Manik is also same. In one proceeding exonerated, in the next proceeding he was penalized.
No, we could not complete because the honorable tribunal quashed the
Was the
charge.
charge.
And I came before your lordship's court, and the honorable lordship's court, my lord, that is this matter. The affirm the cat's order. Pending. The order before is your lordship, under challenge. The order of the tribunal quashing the charge sheet issued against Maniklal by way of a defermental proceeding, my lord, that is a subject matter of challenge in the instant writ application. And now in view of the Supreme Court's order in Tapan Das, I say that this issue is Romo Nes Integra 2006 will be made applicable. If that is made applicable, then what is my recourse? I can revive the proceeding. Why I can revive the proceeding? Because departmental rules, I have shown to your lordship that even if the person is retired, I can, my lord, start the retirement proceeding. By reason of the judicial.
So you pass an order to that effect.
My
Your
lord.
authority have not passed any order in lieu of the submission which you are making.
No, I can't because when the charge sheet was set aside by tribunal, and when I questioned this order before your lordship's court, and which is pending the instant writ petition, how could I take an action, my lord, against this gentleman? Because it is continuous proceeding. I issued a charge sheet against Tapan Maniklal. That was quashed, set aside. Immediately I came before your lordship's court. That is pending, yet to be decided, and which is before your lordship just now. That is the instant writ proceeding. And if the Supreme Court has come in aid of us, my lord, I can take strength from this order. 2006 will be made applicable. The entire foundation or premise of the order passed by the CAT, my lord, tribunal, my lord, taking a note of, my lord, Justice Tandon Division Bench judgment, that goes. Now, Mr. Dash, my learned senior friend, can argue or might say that my client is powerless so far as the new proceeding is concerned. I say no. With humility, my lord, because the rule 2006, my lord, which is still in vogue, these rules are still in vogue, it empowers me, my lord, to start a proceeding. I could not come to a logical end.
Pertaining to the said incident.
Absolutely, absolutely. Because it is a financial charges, it cannot be stale charges. CBI or, my lord, if your lordship says today, Ratan Krishna, my lord, my learned senior friend is not.
Yes, Mr.
Ratan Krishna, my lord, he has no answer.
I was confining myself to the gratuity only of money court as per Rule 61.
Your lordships were asking me Ratan Lal. He is not at.
Two things. One thing, continuation of the proceedings, Maniklal.
Yes,
Continuation of proceedings and payment of gratuity and pension.
payment of gratuity, my lord.
Pension. Two things.
Two things, my lord. Yes, I am asking for two
Not
things.
explained.
First of all, let us look.
Maniklal and other.
Let us look.
First second.
Second to CBI.
No.
My lord, look to the Rule 61.
Cat was.
My lord looks to Rule 61. He is absolutely guided by Payment of Gratuity Act. And that Rule 61 1C of the CCS pension rule is not applicable to BSNL employees. Neither any of the CCA rules are applicable to the BSNL employees. After 1/10/2006, that is the Tapan Das judgment, that is the Supreme Court, Honorable Supreme Court has said. Now, let us see 61.
Where Honorable Supreme Court says that in respect of BSNL employees,
Lordship,
CCS rule 1972 will not be applicable.
Lordship, they say.
Maybe we have missed that line.
Lordship, the judgment at page 3. Judgment at page 3.
Yes.
Yes.
Acha, before that, there is a reference of Rule 58 at page 3 at the top. So, but I go to 4. Learned counsel for the respondent submitted that the charges relating to the year 1999 to 2001.
Where are you reading?
Below.
Where are you reading?
Oh, Tapan the judgment below. Page paragraph 4.
Oh, yeah.
Yes, tell us.
Learned counsel for the respondent submitted that the charges relating to the year 1999 to 2001 were prior to coming into effect of the 2006 rules, and thus rightly the High Court has held that legally the proceedings, if at all maintainable, had to be conducted under Rule.
This is the submission of the respondent.
And thereafter, their lordships straightway said, having considered the matter, we find substance in the contention of learned ASG. Thus, the findings in the impugned order with regard to 2006 rules not being applicable for conducting a disciplinary proceeding for an employee who was under the Department of Telecommunication prior to creation of the petitioner company in the year 2006 would have to be under the 1965 rules is set aside. Partly it was set aside and shall not be relied upon appreciably.
Now this setting aside has revived the entire charge sheet. High Court held in your favor.
Then, my lord,
Then Supreme Court has said that no, 2006 rules are not applicable. This finding given by High Court
that is
bad.
set aside. That is revives.
That is
That
bad.
revives.
So they initiated a proceeding under 65 rules.
Hmm.
Tribunal quashed it. So their stand of the initiation of the proceeding under 2006 rules is proper.
But my lord, lordship,
Just step by step. So
step by
the
step. My
initiation
lord,
of
my lord,
proceeding against them is proper. If it is proper, then you have been exonerated from the departmental charge sheet. One charge sheet you have been exonerated.
that is the main thing, my lord.
There is another charge sheet.
Ah.
That is another criminal proceeding. I'm not understanding this. He has said,
That I'll argue.
please come
yes,
to the
because-
note. Column 1 says exonerated. Please note. Have you got it?
Yes, my lord.
You have not got it. This one which they have,
No,
sir.
I have not given it. তখন তো আপনি আসেননি, sir.
কোনটা? Maniclaw. Yes, that was I was trying to place
So,
before your lordship.
His proceeding which was initiated under 2000.
My lord, the CBI charge sheet was in 2005,
Okay.
and this department
Okay, one by one.
quashed.
One by one, let us. Now let us discuss regarding continuation of the proceeding.
No,
After we shall come into the payment. Continuation of the proceedings. Entitled to invoke 2006
My
rules.
lord, under
You hear kindly.
my lordship.
It will benefit you. So you approach the tribunal that the proceedings initiated invoking under 2006 rules is bad. Tribunal accepted your contention. Quashed the proceedings. Honorable High Court also accepted your contention.
Lordship.
They went to the Supreme Court. Supreme Court says, well, no, they are right. The they have rightly invoked 2006 rules. So the proceedings initiated against you shall
Yes.
revive,
Lordship.
shall revive.
Revives.
So they have the right to take action.
Lordship.
What is your submission? So it is admitted.
That is why I started by saying the Supreme Court at the end. Concluded by saying a quietus shall be given to the entire controversy.
In the particular top,
No, we are also dating, Lordship.
thus in the particular fact of the present case,
That is why I was going to tell you, Lordship. Yes.
this order, this part of the order has not been given effect to in respect of all. In the particular case, in this case,
Why? There was no criminal case against the gentleman.
No.
There is the
Criminal case is there. That is what I was. Lordship, hears me for a moment. What is that charge sheet? Milord, in 2005, I said CBI issued a charge sheet. Now this charge sheet, following the CBI and at the instruction of the CBI, the department issued a charge sheet in 2007, 5/11/2007. All the charges for 5 years, inquiry proceeded. Inquiry officer found that it is not proved. The disciplinary authority also, by his order dated 28/4/2012, that is important, my lord. They exonerated me, and I was in the department on 30th, and 29 CBI put the charge sheet. CBI, at the instance of the CBI, the charge sheet was issued by the department. That is nothing but the replica
What is that
replica of the CBI charge sheet.
What is
And
that?
and
What
my
is-
lord,
where-
what I
where
did,
is that charge sheet?
what
Second charge sheet.
second charge sheet is the replica of the CBI.
আচ্ছা
CBI
সেটা কোথায় আছে?
আছে, my lord, আছে. That is, I'm giving the lordship. They have given, it is their paper, they have given. Departmental charge sheet part, second, page 123,
এটা মানিকলাল, হ্যাঁ,
page 123.
annex.
And my lord, my client attended the inquiry, but all the necessary documents are lying with the CBI court.
হ্যাঁ,
123.
হ্যাঁ, হ্যাঁ।
123.
You just, Mr. Banerjee, page 55 is the first charge sheet.
Yes, page 199,
charge sheet.
first charge sheet.
Yes.
55 first charge sheet. Second charge sheet, where is the second charge sheet?
Second charge sheet is at 123, my lord.
123.
Yes,
four,
it is his application. my lord. It is
Uh,
his, I'm sorry, my lord.
123.
123, it is his
55
application.
is the second charge sheet.
My lord, I was sorry, I was all along thinking
Page
it is my
55 is the
application.
second charge sheet.
4th of April
Page
2012.
55, yes, 4/4/2012,
This is the second charge sheet.
yes.
কিন্তু আমারটাতে তো 123.
Page 122.
4/4/12,
That is the replica of the CBI charge sheet.
Maybe.
maybe.
Oh,
The second charge sheet on proceeding initiated on the basis of page 55. From that, he has been exonerated, Mr. Basu.
The page 55,
Is
dated
the
minute
4th April 2012.
that is the second charge sheet.
Right.
I'm
In this
Oh,
charge sheet, he
in
has
this-
been exonerated.
No, in this
No.
the charge sheet was quashed by the honorable tribunal.
No, no, then exoneration is,
The first charge sheet,
where is that?
First charge sheet,
5/7/2007,
first charge sheet at
195, 195,
195 না 99, যাই হোক আপনার paper.
195.
195. আমার পেপার বলে কি ভুল হবে?
এটা 2007, এটা 2012, তাহলে এটাই past.
195.
199, ঠিক আছে 195. In my copy it is 199. Yes. And my lord, the inquiry officers not to 200 and কত 224.
Now, the tribunal quashed which charge sheet?
Charge 4/4/2012.
55.
Page 55 was quashed.
55 was quashed.
And from the first charge, he was exonerated.
Exonerated. yes.
My lord, inquiry, disciplinary authorities order at page 227.
এইটা quashed করে।
Supreme Court had ordered.
Supreme Court order নেই ভাই।
Supreme Court,
was
he never
exon-
approached Supreme Court.
He was exonerated
221.
in connection with page 55.
না, exonerated
55 is the second charge sheet, 195.
195.
Exonerated from 195.
হ্যাঁ,
That is
195,
5/11/2007. Data ঠিক আছে?
ওটা 2007 এ।
Yes, he was exonerated. And 55 is 4/4/2012, which the honorable tribunal set aside,
That was-
against which minute I came before,
Just now revived.
yes, now I came before your lordship.
মাঝপথে
Now-
আপনি বলবেন।
আপনি মাঝপথে জজ সাহেব জিজ্ঞেস করেছেন, স্যার আমার সেই উদ্ধত্ত নেই আপনাকে থামানো। আপনার মতো
My lord,
ব্যক্তিত্ব
what I was, আমি একটু বলে নি।
আপনি
My lord,
বলুন,
what
স্যার।
I was saying, my lord, this inquiry and everything will show I have not caused any loss to the department, even a copper. And rule
Mr.
61,
Das,
payment
Mr.
of
Das,
gratuity act.
we have tried our best to explain.
My lord,
We are seeking an answer
then
from
my
you.
lord,
Say that you are not agreeable to answer us, we will leave, we will now go through.
my lordship,
We require your assistance.
but I am not on the disciplinary power, my lord. Of course, the charge may revive. Charge may revive as per
So
Supreme
if
Court's
the
order.
charge revives, how can we direct them?
But that is up to your lordship, my lord.
No, no, show us the proposition of law. Unless you give us material, how can we help you?
That is,
You are now saying that in now release my gratuity. This is your grievance, no?
yes, my lord, that is only my grievance is that.
But-
I am arguing on that point only.
But when the Supreme Court says that the second charge sheet is a good charge sheet, they are now in a position to revive that charge sheet. Supreme Court has not spoken anything in that judgment, so it requires substantive argument that now you are a aged person. Your CBI proceeding, when it will be completed, you do not know. CBI charge sheet টা কি exonerate?
21 years running, my lord. CBI proceeding 21 years running.
CBI
And there is no sign of ending it.
CBI চলছে বোধহয়।
CBI চলছে।
CBI case is pending against you.
Yes.
CBI is, so in that circumstances, if this charge sheet is revived, then both the disciplinary proceedings and judicial proceedings will remain pending against you. Now, during pendency of both the proceedings, how gratuity and the rest part of the pensions
Sir,
are
I am
paid to you.
I am only, my lord, interfering. Only, my lord.
Answer.
I'm only 37 capital A, my lord, kindly comes. Mr. Dash, my learned senior friend, 37.
My lord,
CCS pension rule, my lord, kindly come.
Mr.
37.
Mr. Basu,
my lord, my moot question is,
can it not be settled?
No, my lord, CBI cannot settle, my lord. Otherwise, my officers will be.
No, CBI settlement we
No,
are not saying.
no, I come with the
Are
issue.
sir, wait now.
Discipline.
Issue is your argument that now 2006 rules disciplinary proceeding is valid, ultimately held.
Right,
So I have a power to now continue with this proceeding.
right.
Your argument.
And yes, and number one and number two,
And
36.
on this basis, now this is your argument. Vis-a-vis that, please consider the person has retired, you have paid provisional pension. Settle the matter by paying a portion of
My
the
lord,
gratuity.
today, my lord, kindly sees.
Because ultimately, Supreme Court has also, though we do not have that power.
No,
to
no,
confirm.
I never said. My lord, Supreme Court, my lord, only, my lord, my.
Is there, please apply your mind.
I talked, I had a talk with the gentleman said, the officer said, my lord, in Topon, my lord, there was no pendency of the criminal proceeding. Pendency of the criminal proceeding, had it not been the case,
Fine.
এটাই কথা।
with effect from such date as may be notified by the government. Sub-rule 8 says, a permanent government servant who has been absorbed as an employee of the public sector undertaking and his family shall be eligible for pensioning benefits, including commutation of pension, gratuity, family pension or extraordinary pension on the basis of the combined service rendered by the employee in the government and in the public sector undertaking in accordance with the formula for calculation of such pensionary benefits as may be in force at the time of his retirement from the public sector undertaking or his death or at his option to receive benefits for the service rendered under the central government in accordance with the orders issued by the central government. The amount of pension or family pension in respect of the absorbed employee,
Why is
because
going on?
Millard, I say Millard,
From
that
central government, he was.
that is why here Millard, the public sector undertaking, when BS,
Your
now
argument is 69.
69, and also Millard, it says Millard, the family shall be eligible, commutation, he said Millard, he, according to him,
First clause.
clause 8, subclause 8,
Rule
after
37,
rule
37
capital
A, clause 8.
8, a permanent government servant, sorry Millard,
Don't have 37 A. Which
Eh?
page you are reading?
622, 37 dash capital A, এই বইটা একটু দিন তো জজ সাহেব।
এই যে পেজ হচ্ছে
622. Got it?
Yes.
Now kindly read Millard. A permanent government servant, 8, who has been absorbed as an employee of public sector undertaking and his family shall be eligible for pensionary benefits. What is that, Millard? Commutation pension, gratuity, family pension. It includes gratuity.
Yes.
So my understanding of this rule is 37A and 69C, Millard. If you lordship read together, Millard, your lordship will find, pleased to find that according to Mr. Dash's argument, if I have correctly understood his mind, Millard, that these rules are not applicable. 69C, because this is a clear, because when he derives the pension, his entitlement flows from this rule. Am I clear? An entitlement must, there is a source of power. The power means this rule, which entitles him to get pension. If my first limb of submission, Millard, stands, that 2006 rules.
37A 8 says that combined service will be taken into account.
Account and Millard, family pension, gratuity also. Yes, correct. Now Millard, so pension includes gratuity. This pension, I am releasing provisional pension. Now Millard, today your lordships are telling me that if 2006 rules survive, then Millard, what is the consequence? Now Millard, question then comes, which your lordship rightly put, Millard, that whether the disciplinary proceeding, I must have some power and to show your lordship that I derive this power. My answer, Millard? এই রুলটা দেওয়া আছে, রুলটা দেওয়া আছে, দেওয়া আছে, এটা দেখুন না, এই রুলটা দেওয়া আছে, দিয়েছি বলছে, এই রুল দুটো বার করে দিন তো জজ সাহেব, দুটো মোটা মোটা কপি জজ সাহেবকে দিন।
প্রসিডিংসটা এই একটা চিঠি দিয়ে বন্ধ করবে, বলবে যে আমার ডিফেন্স ডিসক্লোজ হবে এই সিবিআই।
Millard,
Proceedings, you don't know what is the state.
Millard,
CI proceeding, what is the state?
that is going on. And my client is in last wait for perhaps. So he also cannot say.
All right, Mr. Vasu, anything else?
no, I have other submission to make.
Yes.
Millard, rule 60 and 61, sorry. This is the rule known as BSNL Conduct Discipline Appeal Rules, affirmed by the Supreme Court, Millard, that with regard to the applicability of this rule.
613.
Not one. BSNL, I mean, din, sir. আলাদা করে দেওয়া আছে দেখুন, BSNL Conduct Discipline and Appeal.
Mr. Vasu will insist highway paper. You will not allow. This way we are searching out like mad persons. Where is it?
No, Millard, it was, I'm sorry, Millard, it was.
We are
Yes,
hearing
Millard.
the matter after 4 adjournments.
Millard, I'm sorry, Millard,
When we say prepare no, huge cost, I cannot do it, etc., dying concern. This is simple irritation.
I'm sorry. 61 Millard.
2006,
Yes.
under which you initiated.
Page 61 Millard. Rule 61. Disciplinary provisions. Rule 61.
That is internal page.
Internal page 41. Rule 61 BSNL. My lords got it? Huh? দেখুন না বার করে দিন। Yes.
Got it.
Disciplinary provisions for retiring employees. The departmental proceeding will continue against an employee after his retirement if the same was initiated before his retirement. Millard, your lordships know that Millard, the departmental proceeding commences with the issuance of a charge sheet. The charge sheet was issued much before his retirement. The disciplinary proceedings, if instituted while the employee was in service, whether before his retirement or during his re-employment, shall after the retirement of the employee be deemed to be proceeding under these rules and shall be continued and concluded by the authority by which it was commenced in the same manner as if employee had continued in service. Now, Millard, I have that power. Now, Millard, when the honorable tribunal quashed the charge sheet, I come before your lordship. Then, Millard, it seems, it is presumed that the original proceeding, it is an original proceeding writ petition, and I approach the first court, and it is a continuing. Why it is a continuation of the earlier proceeding? Because 107 of the Code of Civil Procedure, Millard, if the principle applies here, Millard, subject to correction, that Millard, appellate court exercises God's power. Now, your lordship is exercising an original jurisdiction as well as appellate jurisdiction or supervisory jurisdiction over the Millard, the action of the tribunal. Today, the Honorable Tribunal proceeded on the premise as if Millard 2006 rule cannot be made applicable. Honorable Tribunal derives its source.
Got it.
Justice Tandon's judgment. Honorable Division Bench. That was upset. Millard kindly takes pain to turn Millard the tribunal order. The order, Millard, which ultimately Millard quashed the charge sheet. What is the premise, Millard?
What is the requirement?
Requirement means, Millard, it survives.
So why you are taking us?
No, all right, Millard.
So that's her.
No, if he says, Millard, something, Millard, which is because.
He will get a chance to.
Yes.
Yes, Mr. Das.
My lord, the response from my lord, of course, it is true that the disciplinary case, the second disciplinary case as regards my client, that can be resurrected, and that was resurrected even the day prior to his retirement. And the first thing he said, all right. So,
charge sheet was 4th of April 2012.
But that was delivered on 29th, antedated.
On 30th April 2012.
Yes, my lord. And he was exonerated on lordship, 30th April 2012.
This point which you are arguing today, that fag end of the retirement, on those lines of judgment.
Lordship.
Fag end of the retirement, you cannot resurrect the claim of say 1990. It is a bad charge. But on what point your proceeding was considered, whether applicability of rules, only whether 2006 will apply or 65 will apply. Now, Mr. Basu says that tribunal order automatically goes. So if the tribunal order goes, the entire proceeding revives. So if the entire proceeding has revived, you give that finding to us because it will not be curtailed by any delay because there is a continuity of proceedings. Tribunal dispatched, High Court set aside that order, now Supreme Court has upheld that order. So he's arguing that now you should be like Rule 37 of the new. You cannot now come out of that regard that you cannot bind me under 2006 rules. 2006 rules will be applicable.
I say,
If
Milord.
2006 rules are applicable, then Rule 60,
61.
Rule 61 takes away your right to get full pension. Rule 61
Some BSNL rules.
takes away your.
And, with
Have you
greatest
got?
respect, Milord, here I want to differ.
Yes.
That is the thing, Milord. Because they cannot take the advantage of both Payment of Gratuity Act, Rule 61, as per their law, and Rule 69, 1C of the CCS pension rules
Why? Tell us why.
simultaneously. Milord, I already gave one judgment of Allahabad High Court 3 judges bench.
We want to hear your argument.
Now, Milord, let 61.3, 61, Rule 61.3. Let us go through that. Their rule, Milord. He was there. 61.3.
61 sub-rule 3.
Sub-rule 3.
Yes.
Sub-rule 3, Milord.
Yes.
During the during the
page 41.
Yes, during the
pendency of the disciplinary proceeding, the disciplinary authority may withhold payment of gratuity for ordering the recovery from gratuity of the whole or part of any pecuniary loss caused to the company. And that is what, if the employee is found in the disciplinary proceeding or judicial proceeding to have been guilty of offences of misconduct as mentioned in sub-rule 6 of section 4 of the Payment of Gratuity Act, or to have caused pecuniary loss to the company by misconduct or negligence during his service, including service rendered on deputation or on re-employment after retirement. However, the provision of section 7.3 and 7.3 of the Payment of Gratuity. So here they says it is
should be kept in view in the event delayed payment in case the employee is fully exonerated.
yes, Mr.
so here they says, Miller, that it is entirely disciplinary proceeding is going on, but it is controlled by the Payment of Gratuity Act. Payment of they can hold it by the Payment of Gratuity Act for ordering recovery of the pecuniary loss caused to the department.
Yes.
They cannot held it at their sweet will. He has caused some pecuniary loss to the department.
They will now decide
No, this is the law says, Milord. I am placing the law.
what law.
That is the 61.3 BSLST rules.
But it read it, we didn't follow. What law was
Lordship.
during the pendency of disciplinary proceedings?
Disciplinary proceedings are not really pending.
During the proceeding,
During the pendency of the disciplinary proceedings. Now, as per my client, his disciplinary proceeding is pending. Pending.
Yes.
So this attracts. During the pendency of the disciplinary proceedings, the disciplinary authority may withhold payment of gratuity for ordering the recovery from gratuity of the whole or part of any pecuniary loss caused to the company.
Just stop. Now, whether pecuniary loss has been caused or not.
And that is,
decided in
Lordship,
proceeding.
I bow down to your Lordship. That is why I invoke the first charge sheet. That is why I am saying the first charge is he was exonerated. He has caused no loss to the department. His charge was disproportionate asset because they had a family business and all the family business money was on the sale account.
Second charge sheet.
Second charge sheet.
Charge sheet.
No, second charge sheet, my lord.
First charge sheet has
Same thing.
exonerated.
Exonerated, my lord.
So question of finding guilty in the first charge sheet does not arise. Because
But we can take it because whether he has caused any pecuniary loss to the department or not, because the first charge sheet result comes on penultimate day of his retirement, that is on 28th. Had he caused any loss to the department would not have exonerated him, my lord.
Yes, sir, that is not the subject matter.
Very well, my lord. That this is I tell your lordship, this is the criminal, the same charge in the criminal case pending. Let it be decided then. Let it, whether my case is that my client, they have to show,
So now
no, they have to show they are withholding my client's gratuity. Gratuity is a deferred wage, my lord. We have so many cases.
to show us that rule 61 cannot apply because I am protected by payment of gratuity. Show us, we are wanting to see.
No, I'm saying, my lord, otherwise, I'm saying Rule 61 applies as so Rule 61 stipulates that Payment of Gratuity Act is only applicable to me. No other act. My case is that.
No, let us read.
Lordship, let us read it again. Let us read it again.
I am reading. Please follow me. During the pendency of the they may withhold payment of gratuity for ordering recovery from gratuity to whole or part of the pecuniary loss cost to the company. Now, if the employee is found in the proceedings or judicial proceedings to have been guilty of offences, misconduct as mentioned under section 4(6), or has caused pecuniary loss to the company by misconduct or negligence during his service, or on re-employment order. However, the provisions of the gratuity should be kept in. Now, how does this help you?
That helps me. They have to, on the very first day I said, my lord, you keep the amount that I have, department has incurred loss due to me, whether I have caused any figure. They were mum.
They will not give it.
Huh.
They will now say, I will want to reopen the proceeding. Now I will continue.
Now, one thing is clear. Payment of Gratuity Act is applicable to me. Under that act, they can be told.
Under that act, how can you get when the proceeding is pending? Section 4, come to section 4 of Gratuity Act.
My lord, that I relied on first case.
In case any employee is found to be guilty in judicial proceedings, then
That can only be decided by the criminal court.
sub-rule 3 deals with
Because
both the situation, both the circumstances. If employees
constant to say that in view of the findings of Supreme Court in the case of Kapur Kumar, which upholds that 2006 rule will be applicable. We will say that no further order is required to be passed in the present matter.
The charge sheet has been set aside, so this order must go. Tribunal's order.
Then lordship adds one line. Payment of gratuity. Payment of gratuity also shall be.
I tell you, lordship,
Payment of gratuity also should be decided by the 2006 rule. 61 rule 61 3.
In fact, that is not.
That is all right, my lord. Only one line. One line will do. One line will do.
No, what one line?
Actually, payment of gratuity is
Right,
the subject
only
matter
one-
of the.
No.
So why we are thinking so
No,
much?
Milord, only one.
No, in there, Tapan Das
Milord,
says
no.
payment of gratuity already.
Milord, why
gratuity
Mr.
paid.
Das?
Ratanlal paid, gratuity paid. Ratanlal.
Tapan Das
সব উত্তর দিচ্ছি স্যার
case has totally set as this.
Milord, only one indulgence. Milord, 69C is in line with the
Milord.
mandate of Gratuity Act. Why? Because it says 46B, the gratuity payable on employee may be or wholly or partially forfeited if the services of such employee have been terminated for.
That is in my favor.
Why case similar?
Why case similar?
Sanjay Karobar. He could say that hearing the case was case heard hearing the authorities withheld for the pendency of the proceeding. Anyway, discussion is not here because that is not the subject.
Subject matter.
No.
And not only that,
And
Millard,
Lordship,
Millard, today your lordships, if your lordships are contemplating at all,
No, last paragraph of the tribunal's order, we have no hesitation to quash the charge memo and hold that the applicant would be entitled to receive all the held up retirement benefits within such and such. Therefore,
so that must be set aside.
Supreme in view.
Yes,
এবার
it
সেগুলো-
must go. This must go. And that is why they filed a contempt.
Entitled to receive.
Eh,
They will not be entitled.
No, not the-
And not only that, Millard, 46B says if he's convicted in a criminal court, Millard, forfeiture of gratuity. How could he say?
মরার উপর খাড়ার ঘা নিয়ে
he cannot take
Also-
advantage of both the laws at the same time.
What both the
Either
laws?
payment of gratuity act or 69 months C.
What is
He
saying?
says under rule 58, he says all the rules are scrapped. So I feel
No.
that 69 months C is
I
also
did not
scrapped
say Supreme Court.
because
said-
they have their own law. Because they have their own law, payment of gratuity act and payment of.
Yes, yes, yes.
And Tapan Kumar Das done. And Ratan Krishnopal, that is also.
Ratan Kulpal, CBI
CBI
case,
case pending, Ratan.
CBI
Here
case.
the question of revival of the proceeding does not arise.
No.
So in that case, we have to decide entitlement of.
Entitlement gratuity in view of 69C, 37A,
ওই
and
pendency of judicial
46B.
proceeding.
Suppose Millard kindly contemplate a situation. If CBI court convicts this gentleman, Millard, the forfeiture of gratuity, Millard, where from I recover?
37.
37A capital A, sir, আপনি হাসতে পারেন, তাহলে legislature কে
Yeah,
হাসুন।
that was my plan. 37 is applicable, so charge sheet is not maintainable under
Why not?
2006 for the year. But after Supreme Court, I
37
cannot argue that. I cannot argue that.
37 of what?
37 of the CCS pension rule. That was, that clearly says the person when his option is accepted by the government, right from that day, he
Arre, that is in
ceases
a
to be-
That is in a
ceases to be a
situation like,
government
in a different situation.
he ceases to be a government. His action, all their action, options were accepted in 2004, 12 to 2004. And from that date, they ceased to be a government servant. So till such time, the CCS rule was very much applicable. And that setting up order also I place before your lordship. I don't want to place it.
How does that help you, Mr. Das?
Lordship,
How does that help you?
Akon does not help me now. Tapan Das has expunged everything that I submitted before your lordship.
Instead of please think over.
Lordship. No, he says 37A, that
Yes,
is why I'm saying.
I said because in his,
That is part of his argument. Your argument,
Lordship,
because
lordship.
we have heard
My argument is confined to payment of gratuity act, under payment of gratuity act.
that even if the by virtue of Supreme Court order, the pending proceeding revives.
Milord, that also Supreme,
To us, due to the Supreme Court order, the quashing of charge sheet and the proceeding was bad. Now they are in a position to reopen. Now whether they will reopen or not, we don't know.
My lord, in that,
No, 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 no.
Lordship.
So, when we say that in case of this Ratan Krishna, take Ratan Krishna. Ratan Krishna has been exonerated. In respect of Ratan Krishna, there is no pending proceeding. Only in this matter you can argue that, see, when the proceeding I have been exonerated, in your case there is CBI. In your case, is there CBI? Ratan.
Yes, yes, CBI.
Manikal.
Ratan CBI,
রতন সিবিআই,
Subrata CBI,
মানিকলাল সিবিআই, সুব্রত সিবিআই। এই যে
রতন CBI লিখেছি।
আছে, ওই জিজ্ঞেস করে লিখে যান। রতন কৃষ্ণ সিবিআই।
yes,
and
yes.
CBI charge sheet 2005 is still continuing.
Still
Still continuing, my lord. 21 years.
in the
And I said,
তপনেও আছে।
হ্যাঁ, তপনটা ইয়ে হয়ে তপনটা
Only in Maniklal you satisfy us since the disciplinary proceeding in which they found to be exonerated.
yes, my lord, number one, the first proceeding, I said. But the second one, not yet started now, the very first day. Why not started? Why not started? I tell your lordship, the first day he attended and he told, give us the document of the original. Originals are lying with CBI. They said, we cannot give it. That is stalemated there. That is stalemated there. And it will remain stalemated, my lord.
74 বছর বয়স।
It will remain stalemated. They cannot complete.
মানিকলাল 74 বছর বয়স।
That is why
Exonerated নয় বোধহয়।
রতনলাল punishment
রতনলাল পানিশমেন্ট দিয়ে তাহলে পানিশমেন্ট লিগাল লিগাল
pension to them.
Right, I whether, my lord, subject to correction. If your lordships are not satisfied with regard to Ratan Krishna's stand, so far as we are concerned,
That is, we are saying Ratan Krishna proceeding over punishment.
right, punishment imposed.
Now, only in Ratan Krishna, at best, it can be argued by them that by virtue of the Supreme Court order 2006 which will apply, proceedings in Ratan Krishna, question of revival of the proceedings is not there because that has been closed, punishment imposed. Only in Ratan Krishna, there may be a window to argue whether 69C will be gone into or the Gratuity Act has any overriding effect.
So I need to argue on this, my lord, if someone,
That is what I'm saying. Please
Yes.
clarify this.
yes, yes.
For that, you please go through the judgment of YK Singh
দেখে নিয়েছিস?
and you assist.
Yes, tomorrow?
Yes, tomorrow.
Yes,
Finish it tomorrow.
tomorrow.
Yes.
Point of law, not of law.
my lord, I may be exempted. My submission is over.
No, no,
Tomorrow.
your submission is not over. You please assist us in respect
করবেন?
of Ratan Krishna. In Ratan Krishna, proceeding has completed.
রতন কৃষ্ণ কথা বলবে না, রতন কৃষ্ণের ব্যাপারে নেই।
কাল করবেন? কাল অরিজিনাল সাইড আছে যত সাহেব।
You are
My
for
lord,
all.
next week, my lord.
You are for all.
No, I am for only my money.
Money.
I have finished Manik court. I have said, my lord, if they want to
In
continue
Bengali-
the disciplinary
in
proceedings,
Bengali,
I have
Manik
no
is also
objection. I have
Ratan.
no objection. Finish. Let me see how they are finishing.
In Maniklal, we have said proceedings will revive. Our consideration in the does not any further.
But whether the gratuity will be paid or not, that is the issue. That is the issue.
Gratuity they will.
Proceeding may revive, my lord.
They will be, why they will disperse?
No, well,
Because
that-
the proceedings are now surviving. There
Oh.
will be resurrection of the
Ah.
disciplinary
my lord,
proceedings.
disciplinary proceeding resurrection does not imply that the gratuity should be withheld.
Who was
That is what I was arguing that point only, my lord.
No, you have not shown us.
I'm saying 61, I'm saying, my lord. 61, I'm saying.
Gratuity Act also. What will you learn? You don't have the Gratuity Act with you now.
That's very well, my lord.
কাল করবে
I have given the case flows also. Allahabad court clearly says payment of
What's
gratuity.
that Allahabad court judgment?
it is already placed.
It is already given to your lordship. It is already given to your lordship. I had argued on that point. It is, my lord, a three judges bench, I suppose. BSNL, it is a good judgment of court. Pay para 65.
এটা আপনাদের দেওয়া হয়েছে
আপনাদের
দিন
দেওয়া
দিয়েছে, দেওয়া আছে হ্যাঁ
Which paragraphs you are referring?
I am referring to paragraph 65, the concluding paragraph. The concluding paragraph.
Yes.
Rules 1972 in entirety are not applicable to employees absorbed in public sector undertaking, that is BSNL. Their condition of service are governed only by Rule 37A, read with 5413B of Rules 1972, and absorption letter of applicant respondent number 1 issued by BSNL. Therefore, power of withholding pension or gratuity conferred under Rule 94 and 69 of Rules 1972 is not attracted. B, the service conditions of applicant respondent number 1, that is BSNL employee, with regard to entitlement of gratuity is governed by PGA, Payment of Graduate 1972, and there is no provision for withholding of gratuity during pendency of judicial proceedings or departmental proceedings. Therefore, in absence of any such provision, gratuity or pension of applicant respondent number 1 in both cases cannot be withheld. It can be forfeited, it can be recovered, it cannot be withheld. আচ্ছা
তবে 61 টাকা ওভাররাইট করে যাবে
How does this help you?
it helps me. I said if they want to continue with the discipline proceedings, they can continue with it. But gratuity could not be withheld. That is
Where did you say?
that is the I'm really saying for 61 in the context of the
60, 65.
61
না না
C3
65
during the pendency of disciplinary proceeding. Rule 61(3) of BSNL CDA rules. BSNL CDA rules, Rule 63, Sub Rule 3.
বার করতে দিই 2:1
Yes, 61, what are you saying? What are you saying? 61?
During the pendency of the disciplinary proceedings, the disciplinary proceedings are of course pending. The disciplinary authority may withhold payment of gratuity for ordering the recovery from gratuity of the whole or part of any pecuniary loss caused to the company. Their charge is not relating to that you have caused so loss to the company, pecuniary loss. Achha. If the employee is found in the disciplinary proceedings or judicial proceedings to have been guilty of offences of misconduct as mentioned in subsection 6 and 4, the same Lord, Payment of Gratuity Act says that this can be withheld under 3 conditions. For
how we avoid 61 sub rule 1. You read 61 sub rule 1 first.
that is continuing. I'm saying I'm not objecting to that.
Last portion, he will not be entitled for the payment of retirement benefit till the proceedings are
That I agreed.
completed.
I agreed, my lord. After Supreme
Final
Court, I have
order
to.
is passed thereon,
Aye.
except his own contribution to provident fund, and he will not be entitled for the provision. He will be entitled for the provisional pension as per applicable rule.
Of course, pension is going provisional, my lord. Provisional.
in respect of everybody, right?
My lord, there also Supreme Court is there. Charges committed, charges of 95, can that be revived after 30 years?
That is your hard luck.
That punishing and other cases are there, my lord.
Argue in the Supreme Court.
If they do it, we will raise that point then. If they continue with that, I am agreeable to that. I am participating in the inquiry.
Then
It is-
in that case, how can you claim gratuity? Your CBI will
My lord, at such a delay, disciplinary proceedings cannot run, my lord.
that
That is why,
so
that is,
that point you can take.
that,
Disciplinary proceeding is revived. You can prefer fresh application and saying on the basis of this revival, you cannot withhold my gratuity. Then the court will go into that.
my lord,
Before us, it is very narrow.
my lord,
Charge sheet was that finding has been overruled by the Supreme Court. So proceeding
my
revived.
lord, charge sheet automatically revives after this order. I cannot say anything.
Exactly. Mr.
But
Das.
one thing we have to,
Now, after when
No.
the charge sheet revives, then under section under this rule of 2006,
Ah.
69,
no,
sorry, 61. Under this rule, they have a right to withhold the gratuity.
that they can,
So that is what we say.
very well.
Can show us that this rule 61 will be curtailed by the or rather the provisions of the payment of gratuity have been override this provision. Then now we can consider whether gratuity can be given. Followed. This is our
Actually, I am confining to that only, my lord. For the very first beginning, I said,
that you advance your argument.
very well.
That how on what ground you can say that they must pay you the gratuity. They are paying you provisional pension.
Or be-
as per 60.
Or better, you cannot, your lordship can put it like that, whether Payment of Gratuity Act, provision of Payment of Gratuity Act 69(1)(c) can proceed simultaneously. They will take advantage from this one or that one, whichever is of advantage to them.
No, that,
Lordship,
I'll,
I'll- That is why I submitted Allahabad High Court judgment. I'm grateful, my lord.
Paragraphs you want us
Okay,
to go
প্যারাগ্রাফটা বলে দিন
Paragraph 65 of judgment.
রাজিকে বলুন
Paragraph 65 of the judgment of, yes. That is Allahabad High Court judgment.
ফিক্স করে দিন
My lord, next week, time may be fixed.
You tell us the date.
Monday করে দিন
Finish.
Monday
Pathak
2 o'clock
Monday তো আমি থাকবো। Monday, my lord.
ছুটি সাংসদ জন্মদিন
Tuesday, my lord. Tuesday at 2 p.m.
is not possible. দেখো একটু
একটু পরের দিকে কম আছে সেইটাই
যেদিকে কম আছে
তাহলে কি argument করে?
exceptionally
second then finish up your argument. Please come on that day. If anything you want, give it to me. Hey,
সেখানে আমি থাকবো।
I just want
Millions of views earned. But how do I earn extra?